Good morning, friends. This is Suresh, your commerce teacher from Government Degree College, Kukatpalli. Today, we will try to understand the way in which trademarks are protected in India. You all know what is the symbol of Adidas shoe. You all know, for that matter, what is Adidas meant. It is brand name, isn't it? So, these brand names or symbols affixed to commercial products or services is called trademark. It is one of the important intellectual properties government has formally recognized to protect it from infringement. We have patents, copyrights, and trademarks as an important variants of intellectual property rights. So let us dwell into the history of trademarks, how it is developed into separate law, and for that matter, why should one protect trademarks through separate legal enactments? Right? So let us get started. Well, friends, trademark can be defined as the formal recognition of brand of a product or service, which distinguishes one manufacturer from others and accords uniqueness to the goods and services. You can see below Mercedes Benz, Colgate, SBI, they're all trademarks. Can I establish a bank and apply for the name SBI? No, it is a registered trademark. Similarly, can I start a manufacturing company of cars and apply for the name Mercedes Benz? No, it is a registered trademark. That means trademarks are unique. One product will have unique trademark which others cannot copy, cannot attribute for their products if they are already registered. So your product and service lives on in the form of a trademark, or that grants brand equity to your product or services is called trademark, right? If you see the origin of trademark, the process of assigning names and emblems on the products has been a practice long in use. It's not a new phenomenon. For example, Indus Valley civilization reveals that the manufacturers were induced to affix. That means the civilization forced the manufacturers to affix some symbols to their goods or cargo and to identify the origin, to levy the tax thereon. That means the very purpose in those days for affixing the trademarks was to identify the origin and to impose taxes when cross-border trade take place. So this practice continued to keep its sway even in the age of industrial revolution and unleashed the concept of trademarks protection. Right. So when industrial revolution had started showing its influence on the world, there was mushrooming of products throughout, and these products were required to be recognized with separate names, separate emblems, separate symbols. Accordingly, trademark protection came to the fore of discussion even in the common law of Britishers, right? So, friends, if you see the future of a trademark, like any other intellectual property, it is also an IPR of the manufacturer as well as that of service provider. It is not that only manufacturer will have trademark protection, even service provider can have trademark protection as per as Trademarks Act 1999 is concerned. It can be registered, of course, it has to be registered in order to protect it from infringement or copying by someone. It is protected from the infringement, as I told you just now, that if you registered your trademark just like a property, just like an asset, it will be protected from infringement. Someone cannot use, or no one can use your trademark without your consent. So these are the rudimentary features of trademark, and of course, for that matter, rudimentary features of any intellectual property. Now, after seeing the features of trademark, now let us get connected ourselves to the legal environs of trademarks. After all, why should we require legal protection to trademark? What is the need of protecting it? So, unscrupulous traders, that is, unethical traders, often deceive the customers by dumping the counterfeit goods. Counterfeit goods means duplicate goods. They manufacture similar goods or similar products that are of a very famous brand and make the brand misuse the brand. So they will also affix similar brand or same such type of brand and cheat the customers. So in order to protect the genuine manufacturer who has created brand for himself, we need trademark to be protected. Trademark infringement depreciates the brand image of genuine manufacturer. I told you. Suppose you know VIP English letters, very famous for briefcases and suitcases. I manufactured some inferior quality suitcases and want to have the name VIP. I had V in English, I in Hindi, and P in Telugu. I cheat the customers that it is also a VIP product. Don't you think it depreciates the genuine image of VIP company? Certainly, yes. So, to avoid such problems, to prevent me from misusing the name of VAP or such other names, trademarks need to be protected. Global competition in trade made it obligatory to globalize the brands and to insulate them from external infringements. Right? So, this is the major problem that India had with respect to Trademarks Act before the enactment of new law. In those days, our old law was not protecting the international trademarks when they are not registered in India, especially if the product was not allowed to be sold in India. So, foreign trademarks were not allowed to be registered here. Obviously, Indians were allowed to misuse it. That was too nationalistic. So, in order to avoid such problem, now we are in global market. So there is nothing called one country market, another country market. So wherever consumption is there for your product, that is your market. So you need to protect your trademark from the cross-border infringement by other manufacturers or other service providers. So therefore, we need to protect trademark. One, the customer should not be cheated with the counterfeit products with the same brand. Second, trademark depreciates the image of genuine manufacturer unless it is protected. Third, we trade across the borders, so we need to comply with the global standards and protect our brand image from infringement or copying. So, keeping these three in view, we have to have something called Trademark Protection Act. I told you already that industrial revolution led to the mushrooming of products and services, and there was a need to recognize the products with separate trademarks. Ultimately, the common law of Britishers has sown the seeds of trademark protection. What is common law? The law which is not written anywhere, but the set of traditions and customs duly recognized by the courts to decide what is good and what is bad. So that common law has started recognizing trademarks. And ultimately, when we had independence, we had to implement one law, that is Trade and Merchandise Marks Act 1957. But unfortunately, this law was criticized everywhere for being too much nationalistic. Nationalistic means this law grants undue protection to Indian manufacturers. If an Indian manufacturer misused the foreign name, he was not held for guilt. That was the flaw of that Trade and Merchandise Marks Act 1957. I will give you a small example. See, during 1950s, there was a ban on import of tobacco products into India because we wanted to promote Indian tobacco traders or tobacco farmers. So, foreign tobacco products were not allowed to register their trademarks in India. What happened? One American brand called Now is a very famous cigarette brand in US. So that was very famous throughout the world, that was traded except in India, because in India, importing of tobacco was banned. One Indian manufacturer, Wazir Sultan Tobacco Company, a Hyderabad based company, started manufacturing cigarettes of that ilk, that kind, and also obtained trademark called Now. So normal customers like us will think that this is an American brand Now. But unfortunately, that was, I mean, that is indeed manufactured in India. So how come the American name was allowed to be used by Indian manufacturer without his consent? Because foreign trademarks were not protected in those days as per world law is concerned, unless they were traded, unless the product was allowed to be traded in India. So I am not giving any fictitious names. This is the actual case law that occurred in Supreme Court. So after seeing these criticisms, TRIPS, that is Trade Related Intellectual Properties of WTO, has occasioned Government of India to replace the old act, that is Act of 1957, with Trademarks Act 1999. Of course, which came into full-fledged operation only in 2003. You all know that India is a founder member of WTO. So naturally, we were left with no other option but to implement the protocols of TRIP to protect the intellectual property rights. Same is the case with trademarks. Now let us see the important features of Trademarks Act 1999 and the consequential developments. So Indian government has established the Office of the Register of Trademarks at Mumbai, with zonal offices at Ahmedabad, Bangalore, Chennai, and Kolkata. So to enable the process of registration of trademarks, right? These are the cities where journal offices of trademarks are situated, and you can go and get registered for your trademarks. Number two, surnames, laudatory words, and deceptive words are not allowed to be registered as the trademarks. However, the surnames, which is completely unique and prefixed with other words, can be registered as a trademark. Let us understand this point very clearly. Mere surname cannot be registered as a trademark. What is surname? For example, Tata is a surname, but Tata brands are there, isn't it? Birla is a surname, but Birla brands are there. Honda is a surname. Renault is a surname. So many surnames which we see as brand. And how come it is possible when surnames are not allowed as trademarks? Please understand carefully. If there is any prefix or suffix to surname, it can be used as a trademark, provided it is very unique. For example, only Tata car. Have you seen? No, you cannot. Tata Indica you can see, Tata Indigo you can see, Tata Safari you can see, Tata Tiago you can see. That means some word must be added to the surname Tata. Then it will be allowed to use as surname, right? And that should be unique. So there are so many companies starting are working with surname, like Mahindra is a surname, but only Mahindra car can you see? No, some Mahindra Scorpio. So Scorpio is prefixed to surname, because there can be lakhs of individuals or thousands of individuals with same surname. If one person hijacks the surname and says it's my trademark and others should not use it, it is obviously unfair. Therefore, what law says is mere surnames cannot be used, but you prefix something or suffix something to surname uniquely, it is allowed as a trademark. Next, laudatory words. Laudatory words means something descriptive in nature. For example, I cannot have super good pen, number one cell phone, number one product, or A1 product. That type of descriptive words cannot be given as trademarks because they are laudatory, they are descriptive in nature. Very good product, excellent product. If you go to shop and say, I want some bulb or tube light, then hardware shop will ask, sir, I will give you excellent bulb. So I feel that he's giving me very excellent quality bulb, but he gives me excellent brand name bulb. Don't you think I'm deceived? Obviously, therefore, excellent, good, very good, such laudatory terms are descriptive in nature will not be allowed as trademarks, right? Of course, if those descriptive words are again suffixed with some surname or other unique name, it can be registered as a trademark. Similarly, deceptive or descriptive nature, as I told you, descriptive in quality will not be allowed as trademark. The words and emblems reserved for the use of Government of India under the Names and Emblems Prevention of Improper Use Act 1951 cannot be registered as trademarks. There are some names and emblems or symbols which are registered for exclusive use of Government of India under Names and Emblems Prevention of Improper Use Act 1951. For example, our national emblem, the four-line figure. Can I manufacture a cigarette and use that national emblem on as my trademark symbol? Will they allow? Definitely not, because it is used exclusively for the government usage under Special Act of 1951. So the names and emblems reserved for government usage under that act will not be allowed as a trademark to others, right? The tenure of protecting the registered trademark has been extended from 7 years to 10 years. Please do remember that in previous law, that is under Trade and Merchandise Marks Act 1957, trademark was protected only for 7 years, but now it is protected for 10 years. Of what happens after 10 years, then you have to go for renewal. Otherwise, they will give you a notice, and if you don't respond to the notice, you will forego your trademark. Very, very important, please. Trademark has to be protected because it will stand and it lives on for many generations, not for years. Therefore, you must be very cautious to extend your renewal after every 10 years. So earlier it was only for 7 years. Now it has been extended to 10 years, right? Mere surnames will not be protected as trademarks, but any suffix or prefix is there, you can use it. Laudatory or quality descriptive names or words cannot be used as trademarks. Similarly, names and emblems reserved for government usage will not be allowed as trademarks. And of course, another important development that that took place in the new Act 1999 is protection of trademarks has been enhanced from 7 years to 10 years. Do you have any doubts so far? I repeat that trademark is a unique brand identity or unique identification granted for product or service. And we are seeing the legal implications in India. So the next one is foreign trademarks were also allowed to be registered in Indian jurisdiction. I told you in the previous law, foreign trademarks were not allowed to be registered in India unless the products or services were sold in India. So, if any product was banned from India, the trademark of that product can be happily copied in those days, but not now. Now we are very fair to the global standards and complying with the TRIPS norms and allowing any foreign trademark to be registered in India. Apart from that, we have also ensured something like well known trademarks are protected within the ambit of Indian frontiers, irrespective of its registration. Suppose in global markets, there are some brands which are not registered in India, and yet, if they are very, very famous in global market, our government exercises its discretionary powers and see to it that they will be protected from copying, though they are not registered in India. So, to that extent, we have become pro global markets. Service providers like bankers, education institutions, and insurance entities are also allowed to obtain trademarks which are not available in the earlier act. Yeah, that is very important one, please. In the previous law, that was in 1957 law, service providers were not allowed to use the trademarks or obtain the trademarks. But now service sector is the driver of Indian economy. So it's obvious that we have to protect the brand of services or service sector. Accordingly, service sector now deserves very much a trademark protection. Specific certificates issued by manufacturer or service provider are also eligible for trademark. You often see that advertisements in TV, some jewelry shops give advertisement. I don't take their name here because I didn't take the permission. So if you buy jewelry in our shop, you obtain BIS hallmark certification from our shop. What is this BIS hallmark? See, BIS norms you have to follow being a jewelry seller, but still they say we are giving a special certificate. that these products or these jewelry are purchased at our shop. So that type of certification you can obtain as a unique to your institution or to your company, so that others cannot copy it, provided your certificate is registered as a trademark. Similarly, few educational institutions, private training centers, they can also register the format of their certificates as trademarks. So others cannot copy such certificate formats without their consent, right? So foreign trademarks are also protected now, are also allowed to be registered now, irrespective of the trading. Well-known trademarks are very much recognized by Government of India and protected, irrespective of their registration. Service providers are also allowed to obtain trademark, and certificates formats can also be protected through trademarks, right? Now let us observe another important development that took place in the new act. All the goods and services are classified into 34 classes, such that similar goods of dissimilar classes cannot have uniform trademark. Similar goods of dissimilar classes. What is this? Let us understand. See, in those days, what happened? In class 29, cool drinks, cool water, cool beverages were registered. In another class, milk products was registered. So somewhere in 32, class 32, Amul, you all know, very famous brand for milk products, had its registration. Class 32, Amul was registered. So some person who was manufacturing mineral water that falls in class 29 requested the government, I want Amul as my trademark, and unfortunately government granted the trademark Amul to someone to have Amul water bottles. So why? Because they were in different classes. Water and cool beverages falls in class 29, milk and milk products falls in 32. So trademark of one class can be granted to the product of other classes. How unfair it was, isn't it? But now you see how the point reads. All the goods and services are classified into 34 classes, such that the similar goods of dissimilar classes cannot have uniform trademark. Don't you think that water and milk are similar to each other? I mean, both are edibles, both are food products, food segment, isn't it? So, normal customers like us will be under deceptive mood or deceived that Amul milk products company itself is manufacturing Amul water also, because they're almost similar. Water is edible that can be drunk, and milk is also under food product that can be drunk. So now the new law says, though they are in dissimilar classes, the nature of the goods is similar. Therefore, we will remove the trademark of mineral water. Now he can't use Amul as trademark anymore. That is one sigh of relief granted to the manufacturers having their brand equity in the market. It is possible to have collective trademark for different goods if they are manufactured by a single entity or a person. Suppose I have 3 or 4 product lines. I can have same trademark for all the 4 product lines. It is possible. But if different manufacturers are there, you cannot have single trademark. That is, of course, silly point here. We simply remember that it is possible to have collective trademark for more than one product, right? If they are manufactured by a single entity. The definition of trademark has been enhanced to include the brand name, package, the tagline, and of course, even the color combination also. See, earlier it was like this. I had Colgate toothpaste. You all know blue, red, white combination. It is very enthralling. You can see from a distance and identify that. And adjacent to Colgate, the same color combination, see in the font, bigger font, and or something like written, and some deceptive product was there. That was also allowed to have the trademark. But now government says, our new law says that you cannot have the trademark which is similar to other, not only in terms of the name but also in terms of package, that is color combination, as well as the tagline, right? For example, LIC जीवन के साथ भी जीवन के बाद भी, it's their tagline. I cannot have it, isn't it? So even package, the package color combination tagline will also be included in the ambit of trademark. It's not only the brand name now, so more protection to manufacturers. The new law also enables the registration of geographical indicators or geographical trademarks, right? What is this geographical trademark? If any manufacturer says this product has been manufactured at a particular place, it should have been manufactured there itself, right? Let us take an example. If Tirumala Laddu, you all know Tirumala Tirupati Balaji, very famous god for us, isn't it? So Tirumala Laddu has got geographical indicator. That means if someone gives you Laddu by saying it's Tirumala Laddu, it should have been produced at Tirumala temple precincts itself. You cannot produce Laddu, normal Laddu in some sweet shop and say it's a Tirumala Laddu. You cannot, because the name Tirumala is a geographical area, and that name trademark was obtained. Similarly, in our Telangana, we have very famous trademark geographical indicator, that is Pochampalli sari, right? The weavers of Pochampalli should have woven at Pochampalli. Only then you can say it's a Pochampalli sari. So you cannot do like this, that you manufacture or weave some sari somewhere in the factory of Hyderabad or Chennai and call it as Pochampalli sari. It is cheating, because Pochampalli sari has got geographical trademark or geographical indicator. You cannot misuse that name unless it has been woven at Pochampalli itself, right? So these are the various amendments we have brought into existence through new Trademarks Act 1999 to grant enhanced protection to manufacturers of both India and abroad as far as Indian trade jurisdiction is concerned, right? What happens if you copy the trademark of someone? Is there any provision for penalty or punishment? Yes, you can see in the slide. Any violation of the provisions of the Trademarks Act 1999 attracts the penalty ranging from rupees 50,000 to rupees 2 lakhs, or imprisonment from 6 months to 3 years, or both in some cases, right? The penalty may be imposed, which may vary from 50,000 to 2 lakhs, or sometimes you may also be subjected to imprisonment, which may range from 6 months to 3 years. So be careful while naming your product or service. You must have trademark, it must have registration from the formal offices of the trademarks of India, that is Commission of Trademarks. It must be protected and it must be promoted in due compliance with Trademarks Act 1999. Clear so far? So you must be more cautious while exercising your discretion of using surname as trademark. There may be many people with your surname. So you cannot say my surname is mine, so it's my trademark. If you affix some additional name, you can have surname also as trademark. You cannot use laudatory word as your trademark. You cannot use those words and symbols, emblems reserved for government usage. You cannot have trademark of other product, though it is in dissimilar class, if your product and such other product are of similar goods. You can also try to obtain certificate trademark. You can also try to have collective trademark for more than one product if you are manufacturing. And if you are a service provider, you can also obtain a trademark, and be careful that your trademark lapses within 10 years. That is, after 10 years you must go for renewal of trademark. And don't be fad with the global trademarks. Government says that if well-known trademarks are there in the global market, though they are not registered in India, we will not allow the Indian counterparts to use them as trademarks, right? So this is the entire nitty-gritty of Trademarks Act 1999. Clear? So try to attempt an assignment, my dears. I will give a question. Write a detailed note on the provisions incorporated in Trademarks Act 1999 to protect trademarks in India. Got the point? So friends, that's all for now on trademarks. If you have any doubts, please feel free to revert back at 984956010, or you can also send your queries at nsureshnaidu@gmail.com. In our next class, we will have a discussion on patent law. Then we'll go for Copyrights Act. With that, our discussion on intellectual property laws will be brought to fruition. That's all for now. Have a nice day. Be safe. Bye.